Okay, hello everybody. Welcome back from our break. For our final presentation of this first day of the symposium, I am absolutely delighted to have Mary Foteh, who is an attorney at the Law Office of Mary Khano Foteh PC. And also we have with us the Honorable Ryan G. Salfiti. He is an associate judge with the 308th Family District Court in Harris County, Texas. And they are going to be talking to us about what a family court cannot do for your SIJS case. Thank you so much, Mary and Judge Salfiti. We're so pleased to have you.
Thank you for having us. So Mary and I have presented a few times together regarding SIJS cases, but I have not done so since I was appointed to the bench. Keep in mind there has been a global pandemic for over a year, so sorry if we're a little rusty. If I'm a little rusty, I know Mary's not going to be.
Right. So, you know, Judge Salfiti and I have known each other for many years, and prior to him getting on the bench, we actually worked on some family law cases together in regards to getting the SIJS findings in family court. And obviously, the more you do those types of pleadings and the more you do those types of cases, you realize, wait a minute, why am I not getting this, and what's going on here? Especially with, even though USCIS seems to be being a little bit more receptive in regards to how they're viewing the evidence presented for an I-360 for SIJS purposes. I've been practicing for over 20 years and I'll still get RFEs, and I'm like, what is going on? And, you know, going back to the statutes, going back to my orders, going back to my pleadings, calling SELA for help, it can be pretty intense. And these are definitely some of my favorite cases to handle because the client is a child who needs protection. But again, I think in order to be successful, you have to know what you can and cannot do in the family court, or what the family court judges can and cannot do for you. I think we've seen a really good wave of more and more family court judges being receptive to our pleadings and being willing to listen and even make the requisite findings, even though some of the findings we need for SIJS purposes are not your typical findings out of the family code. So what we have put together for you today is a presentation in regards to what hurdles you'll need to overcome in order to get those findings and to make sure that your orders do satisfy the requirements put forth by USCIS. So
Title V is what controls the parent-child relationship in these type of cases. So we're just going to do a brief overview of what types of cases can be filed and what are really some of the important steps. So I know USCIS has certain standards. Mary, do you want to touch on that very quickly?
Yeah, so we have here at the first slide, you know, in black, I tried to make this as colorful as possible, but that didn't go well. You know, the requisite findings as well as what your client needs to be. Obviously, they need to be a juvenile, and then there has to be a juvenile court that issues a custody order, and it needs to be founded under state law with findings regarding the custody of that child, that reunification with at least one of the minor parents is not viable because of abuse, abandonment, or neglect, and as well as that it is not in the best interest of the child to be returned to his or her home country.
So the types of cases that at least family law judges or juvenile judges can help SIJS petitioners on are divorces, suits affecting parent-child relationships, adoptions, and of course, juvenile offense cases that are handled in the juvenile courts here in Harris County. Divorces and suits affecting parent-child relationships are really what we are going to try and focus on this presentation, because that's what we really see the majority of. Divorces tend to include suits affecting parent-child relationships, so a lot of the same, anything you'll see in a SAPSR, you will see in a divorce. But of course, you can also get these findings in adoptions as well.
And I think the biggest key here is in these family cases that involve children, the prerequisites of Title V of the Texas Family Code must be met. And so that's what we're going to be discussing today.
And so just briefly, this is what our future presentation is going to be about. Discovery, standing. Standing's a big issue, so is jurisdiction and venue. Because if I don't have jurisdiction or the court doesn't have jurisdiction, we can't really do anything to help your clients. And then a huge issue has been paternity, and we were really going to focus on conservatorship as well. And then one of the big things, and I see it highlighted in our presentation, is best interest of the child is key, at least in family law cases.
And in regards to conservatorship and child support, and possession and access, or a lot of times we refer to it as visitation, when you're doing your initial petition and your pleadings, you need to spell out exactly what you want the court to do. You need to make sure your requests are on file. I've seen cases where typically where there's an opposing party and the opposing party will say something to the effect of, "Judge, you can't grant that. That was not requested in their pleadings." And that is true. So whatever you want ordered on final needs to be part of your petition and included in your pleadings or requests to the court, as well as grounds to support your requests.
And even if there is not an opposing party, say a respondent has signed a waiver of service, if you are trying to move forward, I can't move forward on things that you, or items that you did not request.
Yeah, just briefly, really quick there, Judge. You know, a lot of times when we get a waiver, we know we don't really have an opposing party. We just assume, great, default, we're going to get everything we ask for or everything we want. But they still, whatever you want still needs to be proved up with legitimate grounds to convince the court that these findings are in the best interest of the child.
And it doesn't just have to be proved up, it has to be pled for and proved up. So make sure it's pled for, or else you will have to file an amended petition and then get a new waiver of service for that amended petition.
All right.
So briefly, new discovery rules came out in January. I haven't really seen this yet in an SIJS case. Mary, do you want to talk about it briefly?
Sure. So under the new discovery rules that apply to any case filed after January 1st of this year, family cases you can choose which discovery level you're under. We're not going to go into it too much because it's that could be a whole presentation in and of itself. But what I wanted to point out was that there are general disclosures that are now required to be filed by all parties, even if you're not doing formal discovery, and even if you don't request the discovery from the other side. And the rules state that those disclosures, those initial required disclosures, are due on or before 30 days after an answer or an appearance is filed. The question that comes up then, because we're not really seeing how this is going to play out since it's still fairly new, is so does that then impose a requirement to file these disclosures, Judge, when somebody files a waiver? Is that considered an appearance, and does that trigger the 30 days?
A waiver is considered an appearance and it does trigger the 30 days. So make sure, but if it is a contested case, then you may have to do further motions if you do not receive those disclosures.
Is the court seeing, I mean, are the courts enforcing this right now, especially in a situation where it's common in SIJS petitions that there's not really an opposing party?
Are we enforcing it? If a compel is filed, we will enforce it, but I have not seen one in an SIJS case. So,
okay.
The next one, which is a really, really big one, is standing. And I know it sounds crazy, but you need to make sure that your client, who is the petitioner, has standing to bring the suit. 102 lists who has standing, and I want to point out that A1 of 102.003 says a parent of a child. there is a definition of a parent in the Texas Family Code, which leads us to who can be a parent. I understand that I understand that it sounds crazy that mom is mom, so dad should be dad. But unfortunately, that's not always the case. There needs to be a presumed father, an alleged father, or an acknowledged father, or the court has to adjudicate parentage. And of course, 102.03A8, a man alleging himself to be the father. Again, I know it sounds crazy, but I cannot stress enough, parentage and paternity is very, very important. Cases will get dismissed if there is no paternity.
And what we've done here is just list some of the most common standing provisions. There are many more, obviously. But if a man alleging himself to be the father is the petitioner, he's going to have to prove he's dad.
Correct.
A lot of times we have a non-parent coming in under 102.00-03A9, a person other than the foster parent who has had actual care, control, possession of the child for at least 6 months prior to filing the petition. What do you, as in the court, see with the most problems there?
Filing before they hit the 6 months, which, also gets to venue because people try and file in Harris County before the 6 months as well. But I understand that children may be turning 18 and you want to hurry up and get in the court, but I can't do anything if you are a petitioner who is not a parent, who has not had the kid for more than 6 months. So make sure, because it's better, in my opinion, to not file it and then wait the 6 months, as opposed to your case getting dismissed because the court loses jurisdiction and then it's too late to refile.
And a lot of times I think people may assume that, well, by the time I get to final, I'll have had custody, possession, and care of the child for 6 months, but that is not the standard.
Correct.
Okay, we'll go to the next slide, which is jurisdiction and venue. Your pleadings have to include a provision that states the court has jurisdiction and the court must have jurisdiction. I mean, you have to state the court has jurisdiction and why, and it must be true. So when we talk about jurisdiction for Texas, the child needed to have been residing in Texas for at least 6 months prior to filing the lawsuit. And then, so Judge Salfiti and I had a very professional disagreement in regards to trying to proceed under the emergency jurisdiction provisions of the Texas Family Code. And I was educated on this topic just 3 days ago after a very nice conversation. But Judge, do you want to weigh in on that one?
So temporary emergency jurisdiction is just that. There has to be a pretty imminent harm to the child or immediate danger to the child in order for me to take emergency jurisdiction. Additionally, emergency jurisdiction in accordance with the code only lasts for a certain period of time, and that period, during that period of time, the petitioner is supposed to file in the court that actually has jurisdiction. So, like I said, if the child has only been in Texas and in Harris County for 3 months and you file temporary emergency jurisdiction, one, it's hard to get temporary emergency jurisdiction. And two, even if I grant temporary emergency jurisdiction, it may only be for a month. And during that time, the petitioner has to file either in the court of continuing exclusive jurisdiction or in a court that actually has jurisdiction. So if a court hypothetically in a foreign country has jurisdiction, then it would be this court's responsibility to contact the other court to see if they will relinquish jurisdiction to this court. It's not a good idea. Again, it's just temporary orders. It's a very high burden, and I don't think it's going to get you to where you want to be.
So in sum, using that provision of the family code is pretty much only going to get you temporary orders, which are not going to be accepted by USCIS for SIJ purposes, number one. And then number two, may not even lead to final orders at all.
Correct.
And like you mentioned, if there was a court in another country or anywhere else in the States that had previous jurisdiction over that child, this court will honor the fact that that court has jurisdiction over the child unless you can prove otherwise.
Correct. Correct. Another huge thing in terms of venue that is very important, because I've seen this a lot lately. I understand that the Houston metro area is very big, but you need to make sure that your client actually lives in Harris County when you are filing in Harris County. I know some of the outlying cities like Katy and Missouri City, and even some of Spring they border two different counties. If you file in the wrong county, I cannot transfer the case to another county because I don't even have jurisdiction to sign an order transferring. So you need to, I don't want your client to have to waste money filing in two different counties. So make sure that your client actually lives in the county which you are filing.
And I think a lot of times people may assume that if there is a court in, let's say, Egypt that had previous jurisdiction over the child, who's going to know? Well, your reputation is going to know, and the court may ask that. I know Judge Salfiti will ask that question, either of the attorney at prove up or of the client. And so you should not even attempt to, that's basically fraud, right? And misrepresentation. So don't even try to go there. But the other option is if you have a foreign order, you can actually register that here in the States in the court that has jurisdiction and venue, and then seek a modification and attempt to get your SIJS findings that way.
Correct. That's a longer process, but you can do that, yes.
All right, citations and service of parties. Ugh, I hate this part. The petition must contain the names of the parties. So who's bringing the suit and who's your opposing party? Who is the respondent? That could be another parent, or that could be somebody who was granted custody or guardianship over a child, but there has to be an opposing party. And if there is a dad, then you must name the alleged father or a statement that the father's identity is unknown. So Judge, do you want to talk about some of the issues you see with service?
So some of the issues we see with service is one, serving a respondent who is not a parent and just naming them as a parent. You need to name them as an alleged parent. And of course, later on, request to establish paternity. One of the big issues lately has been trying to have a respondent who is in fact deceased. You cannot serve a deceased party, and so you need to find a way to have a respondent. I know you can maybe find somebody else to be some sort of conservator, like a joint managing conservator with the other parent, but you cannot serve a deceased party, and I cannot grant a case if the respondent is in fact deceased. You also need to make sure that how you serve, if we go over to the next slide, is very important, because Texas generally requires personal service on a suit affecting parent-child relationship or a divorce, unless the court has signed an order granting substituted service. So Mary, I think you had a question for me about can a petitioner, when they file the original petition, also file the motion for substituted service right away? The answer is yes. Especially if you're trying to move things along quickly, just make sure you have your affidavit on file as well, and a proposed order. If the respondent is missing, you need to state in the affidavit what efforts you made to locate the respondent. Don't just state, I've done my due diligence to locate them. That's not going to be enough for most courts. I also want to mention that you should, and I think it's in here, if the respondent is a non-resident, you need to make sure that you plead properly for long-arm jurisdiction, and also plead that the child lives in Texas as a result of the actions of the respondent, because I may not have jurisdiction over the respondent, and therefore I may not be able to finalize an order. That being said, if somebody files a waiver of service, if your respondent doesn't live in Texas and they file a waiver of service, they are submitting themselves to the jurisdiction of this court, and you should be good to go.
Okay. One point to bring up in regards to serving people overseas, you know, there are provisions in the Texas Family Code and Texas Rules of Civil Procedures on the different avenues you could potentially use or present to a court to get approved for service. But the other side of that is also some countries overseas have their own rules on how their nationals can be served. The Hague Convention on Service may kick in. Some countries require service be done through a central authority, which takes forever. And then some countries object to using postal channels as a method of service. So it's really important that you cover all that and that it not just pop up on you at final or at prove up and then be sent home, now having to try to serve parties or your respondents.
So one thing that we wanted to mention about the waiver of service is actually incorrect. The waiver of service must be signed after the petition has been filed. So generally we try and tell people not to have the waiver signed until the next day, because most people do not timestamp their waiver of service whenever it's signed by the notary. So you technically can do it on the same day, but it has to be signed after the petition has been filed. But the court also needs to know that it was signed after the petition was filed. So just do it the next day or anytime after that, just to save yourself and everybody else some headache. Also, it has to be notarized. And if the respondent does not understand or know English, you have to have that translated. Have them sign their native language, a waiver of service in their native language, and then make sure that you have it translated back to English by a certified translation.
Right, and so the 24 hours is something that I've always done since I've been practicing, and that's why in my mind it's a law. I made it one. So I always make sure to not let waivers get executed prior to 24 hours. That way there's no issue, and if it comes up, you can answer honestly and truthfully. There's no time difference. There's no, you're not dealing with any of those issues. So that's why it's there, but it's not law per se. It's Mary's law.
And if you do have to serve by alternative service, the court will likely appoint an ad litem, because the court's going to be required to under a SAPSER. So make sure that your client, if this is a private case, is aware that they may also have to pay for an ad litem to locate the respondent. If you are doing a pro bono case or through some sort of agency and they have a list of people that are willing to take pro bono ad litem appointments, file your motion for a pro bono ad litem and maybe put a few names on your motion and some sort of email or something from these ad litems saying that they are in fact willing to take a pro bono appointment. So that way the court knows who to appoint, why to appoint them, and that they will be doing so for no fee, and they're willing to accept a no fee appointment.
Oh, Judge Salfiti's favorite topic.
This is my favorite topic, and if anybody has watched me on docket on Zoom, because you can watch it on the court's live stream, you will know that paternity is a huge issue, not just in SIJS cases, but in all SAPSERs. You must request to establish paternity. I cannot stress that enough. You have different types of fathers. You have a presumed father. So a presumed father would be somebody like if you are married to each other and the wife has a child during your marriage. There's also some deviations to what a presumed father is, but that's generally what a presumed father is. You also have an acknowledged father. That would be somebody who has signed an AOP or an acknowledgement of paternity. If somebody has signed an acknowledgement of paternity, then they are in fact adjudicated the father of the child subject of the suit. The issue, well, so the next thing would be an alleged father, which I think the majority of the SIJS cases that are in front of me are alleged fathers, and people have to replead in order to name them as an alleged father. Because if the parties were not married at the time of birth and there's no acknowledgement of paternity, which there's likely not because the child was born in a different country, then the court needs to establish paternity of the father before we can do anything else. So you need to make sure you file whether you're the petitioner or whether someone is the respondent. If someone is the alleged father, you need to make sure you request to establish paternity. That's a big thing because the court can't grant any conservatorship findings or anything else unless we have a dad.
And what's really frustrating is that dad being listed as dad on the birth certificate is not enough.
Correct. So again, I know it sounds crazy, but even birth certificates is not an adjudication. So make sure that you request to establish paternity. And then you also bring evidence at your approve-up for me to name dad.
And that can include the birth certificate as evidence, as well as your client's testimony, or as we mentioned here, if the laws of the country of birth of the child do state that if someone is listed as dad on the birth certificate, then that means they're dad, then this court, or hopefully any of the family courts, will then give full faith and credit to that finding. And then also if a waiver of service is signed by dad, that's pretty much an acknowledgement of paternity.
Correct. And again, I want to reiterate, as long as he has signed the waiver of service on a petition, that requests to establish parentage. So like I said, that is very, very important because I cannot make any other findings unless I establish either the petitioner or the respondent as dad, unless of course dad is deceased, but that's a whole other issue.
Okay. Next slide.
So make sure you establish them, please.
Yes. Sorry.
I will have to bring you back 3 or 4 times for you to do it. And it's easy if the petitioner is the alleged father. Of course, that's even easier because they can just announce in open court that they're the dad, and then I can establish him as the dad.
All right, moving on to conservatorship, possession and access, and child support. We mentioned earlier your petitions must include requests as to what you want the court to find and why. And then those requests need to be proved up at final. Don't forget that USCIS wants to see findings that are grounded in state law, the relative state law. So there is going to be some creativity on our parts in regards to getting the best interest findings intertwined with the Texas Family Code, and then also meeting the burden of the SIJS required findings.
And it is hard, but it is doable. But I need people to understand that these are rebuttable presumptions. So just make sure you rebut the presumption and argue why it's in the best interest to rebut the presumption. The first presumption is joint managing conservators is for the parents. So that's the first rebuttable presumption. So if you don't want people to be named joint managing conservators, then you need to request the court name one of the parties sole managing conservator. And then if you request the court to name one of the parties sole managing conservator, there is then a presumption that the other party will be named a possessory conservator.
With rights.
Correct. Now I can name somebody a possessory conservator, but still not give them possession and access. But there is a presumption that they will be named a possessory conservator. So if you do not want the respondent named a possessory conservator, then you need to plead that it's not in the child's best interest for the respondent to be named a possessory conservator. And conservatorship and possession and access are two different things. I know the word possessory and possession are very similar, but conservatorship and possession access are different. So you need to plead both.
The same thing goes for the possession and access then in regards to visitation. If you don't want any visitation rights granted, as per the presumptions in the Texas Family Code to the respondent, again, plead for it and explain why.
Correct. And, the abuse and abandonment and neglect can be used as reasons why there is no possession and access. Same reasons would go for why it's not in the children's best interest for the respondent to be named a possessory conservator.
And have a standard possession order, because that's the presumption, right?
Correct. That's a presumption. So make sure you get over that hurdle and then get over the hurdle of no possession and access.
And I think you can do that by pleading, obviously no possession and access and why, and then also you can plead in the alternative potentially that any possession and access periods will be via agreement between the parties, even though hopefully, that will never happen. But it brings us back to another point in regards to respondent. If the respondent is deceased, that is not a legitimate reason for a SAPSR.
Correct. Well, I can't grant a SAPSR if the respondent is deceased. So I know people have found creative ways to have SAPSRs, like naming an aunt or an uncle or a cousin as a conservator. That way, mom may be respondent, or the aunt and uncle will be named respondent, because I can still make those findings for the deceased parent.
Okay. So just to get in a little bit more detail in regards to overcoming the family code presumptions, we've listed here. We're not going to go through all of them, but it's really important to take a look at what the Texas Family Code, and we're actually lucky that the Texas Family Code specifically defines abuse, neglect, and abandonment, which are the buzzwords for USCIS. So I always try to put these in my petitions and in my orders as a reference to the court. You kill two birds with one stone, because then you've got these in your orders for the SIJS purposes. We've listed some other related code provisions: intentional use of abuse, physical force, a pattern of family violence, neglect, significant impairment of the child's physical health or emotional development, or voluntary relinquishment of actual care, controlled possession to a non-parent, which a lot of times, unfortunately, is common in our SIJS cases.
It's very true.
Presumption, parental reunification not viable. You're shooting yourself in the foot if you're going to allow a court to grant possession rights, visitation rights, when you're trying to show that parental reunification is not viable. Your ideal situation is that the respondent has no rights, not in regards to education, medical, health, passports, and no visitation rights. That all goes to show USCIS that the family court took into consideration what you presented and found in the child's best interest that these things have happened, and that reunification with that parent is not viable.
Big thing here is child support and health insurance. I believe I am required to make a parent obtain and maintain health insurance. Whether or not that parent actually does it is beyond my control. But if you are at least in front of me, I will require that most likely the sole managing conservator be ordered to obtain and maintain health insurance. If you want child support, I may be able to order child support depending on if the respondent signed a waiver of service and subjected themselves to jurisdiction of this court. 95% of the people do not want child support, but it still needs to be either pled for no child support, and also when I order it, or don't order child support, you still need to have a child support section saying there is no child support. Make sure that it's in your final order.
And I think also if you are pleading for child support, you can't just put an arbitrary number, $1,000 a month. That's going to have to be proven up as well. Are the courts more comfortable with at least putting child support based on minimum wage?
It would have to be minimum wage. There's a presumption of minimum wage. That being said, if the respondent doesn't live in this country,
right,
you're gonna have to tell me what the minimum wage is in that foreign country for me to kind of figure out what to do about child support. And it's going to be a huge burden, because I can't in good conscience make somebody pay minimum wage child support, which is about $225 a month, when they potentially don't even make that a month. So be careful with the child support thing. That's all I'm going to say.
Right. Okay. So let's talk about exhibits that are pretty necessary or important, I would think, to be filed with the petitions and even before finalizing. We talked about the statement of health insurance availability. I typically file that with my original petition as an exhibit, stating whether the child has health insurance now and then the details of that, or the child is in the process of obtaining that. I know that I've seen some petitions that ask for this requirement to be waived. Is that something you have authority to do on final?
I'm sorry, I got distracted. What'd you say?
Are you signing an order? I'm just kidding.
No, I wasn't.
No, the statement of health insurance. I've seen some pleadings that say there's no health insurance available now. We're in the process of getting it, and asking the court to waive that requirement. Is that something that a court has authority to do?
Yes.
Okay. Again, needs to be proved up.
Yes.
File your waivers. Again, make sure that they comply with all the requisites. UCCJEA affidavit as per 152.209. It's my understanding that this is required to be filed at some point before final if the parents don't both reside in Texas.
Correct.
Birth certificate, certified translation, affidavits with certified translations, country report if needed, proof any documents issued by the foreign country are legitimate and should be accorded full faith and credit. That kind of goes back to the birth certificate issue we talked about. Judge, can you think of any other exhibits or documents that may be relevant?
I don't like this. I don't like the children in the courtroom. I think that this is a very adult situation, and us as a court and as a society should try and shield children from as much as we can. Even if you have the children may have seen enough in their entire lives and may have heard enough in their entire lives. I don't really want them or need for them to have another traumatic experience by being in a courtroom with a big scary man sitting up there. So if you want the child's affidavit, that's fine. I want to state that while you may have filed these things online in the court's file, judicial notice is not evidence. So if you want the children's affidavit, the birth certificates, country reports, all of those things should be introduced as evidence. And let's face it, there's not going to be anybody here to object to them. So please, please, please offer them as exhibits, label them correctly, and ask them to be introduced as evidence. So then that way they will be introduced as evidence. And then whenever you get a record from the court reporter, they'll be in the court's record.
And one quick statement or comment about the court not necessarily wanting to hear from the child. I always have the child present outside of the courtroom just in case. Do not bring your kids into the courtroom unless asked or requested.
When it's not virtual, they are generally in the hallway, but
Right.
it's very rare that I do want to speak to the kids during a prove up or during a hearing. Maybe afterwards I'll bring them in and just talk to them as humans once I take the robe off. But like I said, in the actual hearing, I don't need to grill a child. I just don't. I think your client should be prepped enough to know what to tell me and how to get to where you want to get to.
Well, and that brings us to prove up and final orders. I know we've already kind of stated this, but make sure your orders, include everything you want and why. Be prepared to show why or prove why. Even though you don't have an opposing party, judges can ask questions and they can question what you've presented. They can question statements. They can ask for clarification. Obviously, a court is not going to grant you what you don't ask for or what you prove up to them. And then the other point here is that most courts will not keep jurisdiction until the child turns 21, because at 18 in Texas, they've aged out, as we say. Judge, you want to go through the prove up list?
Yes. So make sure that you prep your client. If the hearing is being held virtually, make sure your client knows how to use Zoom. Make sure you have a certified court interpreter that is required by the government code. And make sure that your client and the interpreter know how to communicate with each other. Whether that be by a second device or whether the court has set up, sometimes the court is able to set up auto translation. Make sure that your client and the interpreter know how to communicate. Make sure your client is dressed appropriately, and that goes for anything. I have had, and this is not SIJS specific, but I have had numerous people appear via Zoom, not dressed appropriately for court. I may be in a virtual courtroom, but it is in fact still a courtroom. And make sure you check with the clerks and the coordinator of the court before you just show up to the courthouse. I believe, at least in Harris County, the 245th, 247th, and 308th do require a pretrial for an SIJS case. I'm sure others may as well. So make sure you check with the court and you don't just show up on the uncontested docket. Also make sure that you request a record. If you are in front of the associate judge, some associate judges may not have court reporters readily available. So make sure that if you are being heard in front of the associate judge, you get a court reporter. Judicial notice, I've briefed on that. It's not evidence. And I cannot stress this enough. I cannot grant what you have not asked your clients. So make sure that you ask your clients that their child is not married. Make sure you ask your client that if the child was returned to the home country, who would be there to care for the child? Make sure you ask your client these things, because if you don't ask, I can't grant that. Also make sure your client knows what you're going to ask or what I may ask. you know, like I said, one of the issues is if the child was returned to the home country, who would care for the child? Well, if there's a whole list of people that are willing and able to take the child in, I may not be able to find that certain aspect of what you're asking me to find. I also need you to ask very specifically, reunification with the other parent or one or both parents, depending on who's the petitioner, is not viable. If you don't ask that, I can't order it. So make sure that you go through not just the conservatorship issues for the Texas Family Code and possession and access and child support, but you also go through the special findings that you are asking the court to make. I do not care how the child got here. I'm not entirely sure why an attorney would ever ask their client on the record how themselves or a child got into this country. It is a record. So make sure you do not commit malpractice and ask your client if they hired a coyote to get the child to Texas. I don't care about it. If I did care about it, I would ask it. So make sure you guys do not ask that question, because it is almost malpractice, if not malpractice, to ask that on the record.
And the other thing, Judge, and I think there's several judges that have talked about this, but the immigration status of the petitioner should not be relevant. I know some judges care, but for the most part, I think that issue should not be one.
To me, it's not relevant. I just care if I have jurisdiction. So if the child's here, I don't care how they got here, but I need to know the child's here and that they've been here for the required period of time so I can make these findings. So it shouldn't be relevant. It shouldn't be relevant. The child's immigration status shouldn't be relevant, but also the parent's immigration status to me is not relevant. Like I said, if the judge asks, that's a different issue. Your client may have to answer, but you shouldn't be asking that question.
And a story comes up, and I know I've talked to you about this before, that sticks in my head. A Fort Bend County family court judge was telling me about a prove-up. It was an adoption termination with SIJS requested findings. And at the end of the prove-up, and this goes back to prepping your clients, at the end of the prove-up, the attorney said, I have nothing further, and judge said, so petitioner, you understand an adoption is basically making you as if you were biological mom. You're willing to do that. It's in the best interest of the child. The child was in removal proceedings, and the court said, so if the child ends up getting deported next week after I grant this order, are you going to go back to the home country to care for the child? And as biological mom now. And the petitioner was like, oh, hell no, I would never go back there. I don't know what I would do. No, this is my home. She denied it. She denied the adoption. And and it sticks in my head because a lot of times as attorneys, we want to tell the story and the struggle to get here, for example. When you talk about I paid a coyote to bring the child here, because in our minds, it goes to showing the court, what this child has been through. But you need to be really careful because you're also potentially setting up your client for a bad result.
Right. I mean, and especially since it should be on the record.
Right.
I mean, all someone has to do is obtain that record, and
sure,
that's not good.
Oh.
So the next slide is I'm going to go through some complaints from the court. The court's perspective. I'm sure you guys have a whole bunch of complaints from y'all's perspective for me. But the big thing is of course, requests to establish paternity. I cannot stress that enough, because if not, you will have to replead, then you will need a new waiver or a new citation, or even potentially a new publication for the citation. So make sure that you plead properly first go around. Second thing is when you show up to the prove up, not only do you need to be prepared, but your client needs to be prepared for what is going to be asked. I understand that some of what we talk about in these cases is very emotional. I'm not oblivious to that. I have no problem going off the record, giving someone a moment to compose himself. But your client needs to be prepared to know that I need to hear these things in order for me to make these findings. On the flip side of that, your client should also be prepared to answer the questions that are asked. I have had an SIJS case where the petitioner was stating that a parent abandoned and neglected them, and the child wasn't able to go to school, and the child had to work for a living to take care of himself. So he came to Texas to live with a petitioner, but the child still wasn't in school. And when asked why, the client said, or the petitioner said, well, he has to work to pay for rent and food. So basically, the child is in the same position here in Texas that he would be in the child's home country. I'm not entirely sure how I could make a finding of abandonment and neglect from the other party's standpoint when you kind of are doing the same thing. In order for me to name you sole managing conservator, you need to take care of the child. So I know that sounds harsh, but and I'm not oblivious to money problems. I'm not saying that I grew up super wealthy, but I'm not oblivious to money problems, but it's a child. And I know that being in school is not a prerequisite for an SIJS case, but child has to be in a better position here than in the home country. Make sure that you rebut the presumptions of the Texas Family Code. If you want to be named sole managing conservator, rebut the joint managing conservator presumption. If you don't want the respondent to be named possessory conservator, make sure you rebut that presumption, and make sure you plead for everything. Also, I know it sounds crazy. I pre-trial before I give people a trial date for these cases. But sometimes, in between pre-trial and trial, people will amend their petition, show up to trial, not having served the respondent, or not having received a new waiver of service, or did receive a new waiver of service but wasn't translated into English for me. I can't move forward on trial. So if it's an actual trial date, your case may be dismissed. Sometimes I'm nice and give them a new trial date. I'm going to go with 99.9% of the time I give them a new trial date. But it happened recently on a Friday, and the child turned 18 the next Tuesday. I worked through lunch on Monday before the child turned 18. I set a trial during lunch, and it kind of worked out. I don't mind working through lunch, but there's an issue is when I'm working through lunch, the staff is working through lunch. So please make sure you do not do that to a whole group of people. Make sure everything is in order when you show up for the prove-up.
Well, I think that wraps up our presentation. Well, I don't know how much time, I keep looking at my watch, but then I don't know how it's moving so quickly, but I do want to give a shout out to Judge Salfiti and Judge Lopez because they have actually been really receptive to the immigrant community and even held their own CLE. I think it was in 2019, which now seems so far away, that about this issue as well, and the orders for SIJ and what they want to see on SIJS orders. And they're actually very helpful judges. So thank you very much for your time and your willingness to listen, because honestly, at the end of the day, that's all we can ask for as attorneys, is that a court will at least listen. I've been in front of judges who refuse to even listen to a case when they find out SIJS findings are being requested. So thank you very much for that.
Listen, I know I have a mean face, but I promise I'm not mean, okay? Mary, I want to thank Mary because she's the one who put the slideshow together. Even though we discussed what would go in the slideshow, she's the one who actually put it all together while I was super busy. I do see some questions in the chat, and is it okay if I answer one? I don't know.
I'm going to stop sharing.
Okay.
Yes, feel free to go for the questions there, or I can read out some to you guys. Either way works.
So someone asked, what recommendations for a dead father respondent who neglected the child before death? I've actually had a similar case in front of me. The petitioner was a family member, I believe it was an aunt, and they named the respondent as mother. And then the aunt and mother were then named joint managing conservators over the child. But then I made the findings from the deceased father. But again, they proved up that was in fact the father of the child. So that's an avenue to go.
Judge, if you don't mind, I'm going to look up at the beginning. I'm trying to go to the top so we make sure we get all the questions. Is SIJ still an option for a UAC who will turn 18 within the first 6 months in the US? I think we kind of addressed that because you have a jurisdiction problem.
Right. I cannot grant an order for conservatorship once the child turns 18. I can order child support after the child turns 18, but that's not going to help you guys out very much. So make sure that once the child turns 18, the case is done. Somebody asked, am I reluctant to grant service through social media? Yes and no. I'm usually reluctant to grant any sort of alternative service because I'm going to go, the majority of people in their affidavit do not include either attempts to serve or do not include what due diligence was done to locate the respondent other than I know he has Facebook. So you at least need to try to find the respondent to personally serve instead of just saying, well, it's easier to just serve via social media. You should try to serve personal service first.
What about in the case of a SAPSR where a foreign court has adjudicated child support only? Would registration of that order be required? I'm going to try to answer and say I would, and attach it as an exhibit showing the court that only child support was ordered. I mean, it's a court that with potentially continuing exclusive jurisdiction, even though it was just a child support issue. A lot of times, even here in the States, we'll get the attorney general cases that adjudicate child support, and then we come in and try to modify, and we attach that order and say, this is the previous order that was issued, judge, and these are the things that we want to modify. So even if conservatorship wasn't taken care of in the foreign court order, it still issued orders related to that child. I would register it just to protect my back.
Teresa, if I don't get to you, you can just message me later. Recommendations if the child's biological father is not on the birth certificate and father is nowhere to be found. It's hard because I'm not entirely sure mother's testimony alone is in fact enough. So you likely will have to do some sort of publication, and an ad litem will have to be appointed for the respondent, and then you're going to have to produce enough evidence and testimony, whether that be from an additional witness to state that that is in fact the father of the child.
What documents would you need from another country to give full faith and credit to the birth certificate? I'm assuming statutes, codes.
Right. People do it all the time. I'm not entirely sure what I believe is El Salvador. If the dad's on the birth certificate, apparently El Salvadorian law states he's dad. Get me that and introduce it as evidence along with the translated birth certificate, and then I can then establish him dad in our courts. So that's really good evidence for me to then establish him as dad.
And on that same note, are the family courts or Texas courts in general required to give full faith and credit to birth certificates from countries? I mean, that would be a good brief to write.
Yeah, Juan, you may want to brief that for me. and let me know. I think it's good evidence that will lead me to establish paternity. And I generally would establish paternity if you have the birth certificate and you have the law from that other country.
But does the code require you to give full faith and credit to a birth certificate or another document?
I think it does, but
I think it does too.
I still would establish though.
Right. I mean, but I think you have a good argument there, because even when you look under the UCCJEA provisions and what we were talking about with temporary emergency jurisdiction, the Texas court is going to give deference to another court if they've issued an order, and at least reach out to them and say, hey, what's going on? Are you guys still interested? Do you still have jurisdiction if necessary? So I think that in and of itself will give, there are provisions in there. I can't remember them off the top of my head, but that you could use to argue.
And Tina, that's a very good question. There is actually a code section in the parentage section that says basically anything that it requests to establish paternity can be done to establish maternity. So it may be as rigorous if it likely will be as rigorous if the petitioner is not the mother. Diana, what about a temporary restraining order? That's temporary 14 days, and the only things that really can be in a temporary restraining order, unless you request extraordinary relief under 105, are disturbing the peace of the children, removing the children from the school which they're enrolled, hiding or secreting the child from the other party, and making disparaging remarks regarding the other party in the presence of the child. So again, it's just temporary, will only last 14 days, so it's likely not going to get you where you want to go. And also, those are done by submission in most courts, so you're not going to get a record.
I think their last one was recommendations for dead dad respondent who was neglectful before death. Can petitioner have a co-petitioner instead of having another respondent, uncle, cousin, etc., and ask the court to name that co-petitioner as joint managing conservator? So
I briefly mentioned on that, do not name them co-petitioners, name one petitioner and one respondent. And then I can name them both joint managing conservators, but still make those findings that you want for the deceased parent. But the deceased parent has to be parent. So make sure you get that to me.
Well, and I want to point out something here. We're assuming that all of our SAPSers will eventually end up in Judge Salfiti's court, who's receptive and kind of gets this. But let's talk about the situation where you're in front of a judge who can't wrap their head around these concepts, doesn't want to, doesn't like it, think that they're giving a green card to a child who came here illegally through Coyote and that whole thing. You need to be really careful about the parties you name, because you do not want a judge to find that you are fishing for parties in order to get an SIJS finding or a SAPSer. It ruins it. It ruins their trust in the attorneys. It ruins their trust in what they are supposed to be doing. And we get a lot of pushback that way. So you really, I mean, as much as we need to be creative, we really also need to be careful to make sure things are true and legitimate and have a real tie to what we're doing, because those judges are still out there. And so we need to try to make it as easy and smooth as possible for these judges so that they will get more comfortable with these concepts and more comfortable with these orders for all of us.
I think we're out of time, Mary.
I think so.
I was going to say on that note, thank you so much, Judge Salfiti and Mary Foteh. We really appreciate it. You know, lots of great questions from the audience. This is obviously a presentation that was very needed.